Free speech and free press in the First Amendment were put at issue in the 1964 case of New York Times versus Sullivan. The majority opinion was written by Justice Brennan with a concurrence written by Justice Black, joined by Justice Douglas. And all justices ended up standing up for free speech and against defamation in that case. The case took place in the stormy 60s. You had the plaintiff, originally L.B. Sullivan, who was a sheriff, and there were some ads about the civil rights protests, ads in the New York Times. They said stuff like, quote, "They arrested Dr. King 7 times. And Mr. Sullivan took issue with this. He specifically argued that this would be read as referring to him, even though it was not specifically referring to him. Nothing in these ads once referred to L.B. Sullivan by name. So he said, oh, this could be read as referring to me. He argues that the paragraphs in the ads would be read as imputing to the police, and therefore to him, the padlocking of the dining hall in order to starve students protesting for civil rights into submission. So he was very concerned about these ads, about these student protests and the police response to it, impacting his reputation, even though they never mentioned him once. And so he takes this to court. He takes this to court, and what happens, it's in Alabama, the Montgomery County Circuit Court. A jury ends up finding in favor of him, and not only that, but they give him $500,000 in damages awarded to him exactly as he wanted awarded to him. So he gets what he wants, $500,000 in the 1960s. Wow, that's a lot. And it doesn't seem like he was really harmed reputationally by these ads. So obviously there's an appeal and a petition for a writ of certiorari. This gets up to the U.S. Supreme Court with our 9 Supreme Court justices. This is a really liberal Supreme Court at this time, actually, in the 60s. It's the Warren Court. Earl Warren was a Republican, but a liberal guy appointed by Dwight D. Eisenhower. They side in favor of free speech. Justice Brennan is not fond of the arguments advanced by L.B. Sullivan whatsoever. So he articulates the standard for what a plaintiff needs to show to win a defamation case. Quote, "For a winning claim of defamation or libel under First Amendment, there must be a showing by the plaintiff that the defendant knew a statement was false or was reckless in deciding to publish the information without investigating if it was accurate." And then he says that the evidence here doesn't even show that it was concerning L.B. Sullivan at all. They didn't mention him by name. So that right away is just extremely problematic for Sullivan. But then also, he just straight up fails the actual malice standard. Sorry, dude. No actual malice here, Justice Brennan says. The judgment against the 4 clergymen is baseless, as is the judgment against the New York Times. There were actually 2 groups that he was suing, the clergymen and the New York Times, and he finds that, yeah, neither of them acted with actual malice. He says it's unconstitutional for Alabama to instruct that where general damages are concerned, malice is presumed. And he points out you can't rely on presumptions to get around the constitutional mandates of our amendment, our Bill of Rights. So yeah, that's a load of nonsense from the Alabama court. That is not constitutional. He quotes Madison, Justice Brennan does, quote, "Some degree of abuse is inseparable from the proper use of everything. And in no instance is this more true than that of the press." Yeah, great point. Great point. We have free press. We don't want to discourage the press too much from going hard against people. Sometimes they might stretch things, but it's not worth bringing them to court for. And that would have a chilling effect on free speech if we allowed a guy like L.B. Sullivan to actually win this case. Could you imagine if it went the other way? Yikes. There would be so many lawsuits. And the current justices on the U.S. Supreme Court, although conservative, unlike the justices back on the Supreme Court in the 1960s, are generally not fans of opening the floodgates of litigation. So I want to read this concurrence too. We'll take a look at it, by Justice Black. He says that malice is hard to prove and is abstract, so he's being kind of critical of Brennan in that way. Like, really, that's a pretty amorphous term, malice. He says a requirement that it be proved doesn't provide enough First Amendment protection, not as much as was intended by the founders. He says he votes to reverse exclusively on the ground that the Times and individual defendants had an absolute, unconditional constitutional right to publish in the Times ad their criticisms of the Montgomery agencies and officials. State libel laws threaten the existence of an American press for publishing unpopular views on public affairs and criticizing acts of public officials. So yeah, you're in the public, you made the choice to become a public figure, you're gonna have to deal with some degree of criticism. You're gonna have to deal with some degree of criticism that at times is misleading, that at times is not fully true. But yeah, it's gonna be very hard to win a defamation case when you are a public figure and you don't like what someone is saying about you. This is super relevant in current times because President Trump likes to do this a lot, or at least he likes to bluff and say he's gonna sue people for defamation. It's something we see a lot online where people someone will post a statement that seems to be stretching the truth about some public figure, and then someone else will respond in the comments, like on Facebook or X, and say, oh, I hope they sue you for defamation, punk. You're lying about them. And it's like, this person saying this hasn't read New York Times versus Sullivan. They're not familiar with defamation law, I'm sorry to say. But yeah, this case is really interesting because it actually did produce a drastic change to defamation law. Defamation law actually existed all the way back before our nation's founding, actually. There was a 1730s case of defamation that was really famous. Yeah, it's been around a while. They tried to define it in the first restatement of torts in 1938, which that's basically just, the restatements are basically statements of the common law as they exist through court decisions. And yeah, they obviously were a lot more willing to allow plaintiffs to win in defamation cases back then. So this 1964 case, this is massive. What a big year. But actually scholars argue that in the 80s and 90s is when defamation law really started to explode. And there's plenty of cases there to talk about. But yeah, I hope that this video is helpful to you in understanding defamation law. I think it's a really well-written case. I think Justice Brennan's opinions on free speech are pretty solid, and he balanced the policy concerns with the First Amendment concerns. Justice Black's concurrence is pretty interesting. He's a First Amendment absolutist, a free speech absolutist, who says that no law means no law. Same with Justice Douglas. So yeah, this is a really good case to know if you want to go into constitutional law. If you're an undergraduate student or a law student studying constitutional law, I hope that this video is helpful to you in understanding that. If you're in a First Amendment course, I hope that you're able to ace it as a result of this discussion, this video. I always aim to give people straight A's with my discussion of the law. No law student left behind, no attorney left behind, no undergrad studying law left behind, or heck, you're maybe even in high school reading this. I had heard of it in high school. So yeah, it's a huge decision. Let me know what you think in the comments about this decision. Like, comment, or subscribe. Thank you so much for watching. I'm having a bit of a hard time talking today. But yeah, as always, I look forward to speaking to you in my next video.